Joining us today for our second part of a two-part webinar series covering an introduction to a private client law. My name is Cacy. I am the head of employment here at Dragon Argent, and I will be asking today's questions. I'm joined with James McMullan from RIAA Barker Gillette. James is the partner and head of private client law, and he'll be helping us today to navigate and answer your questions on lasting powers of attorney. James joined us previously to answer your questions on wills, estate planning, and inheritance tax as a business owner. So today he'll be joining us to answer the second part of your questions for lasting powers of attorney. So let's dive in. Thank you, James, for joining us today.
Hi, Cacy. Thank you for inviting me along again. Good to be here.
So today we're talking about lasting powers of attorney. Please tell us what a lasting power of attorney is, and it's often referred to as an LPA. Am I correct?
LPAs, yes. So LPAs for short. An LPA is a deed that you would sign whilst in good health and sufficient understanding to know what you're signing and the implications of the deed. You appoint one or more persons to act as your attorney, your agent, so that they would step into your shoes, make decisions for you, manage your affairs in the event that you were to lose mental capacity at some point in the future, or indeed suffer a physical injury or ailment, which would effectively prevent you from managing your affairs.
Why should we have an LPA in place? What's the benefits of it?
Okay, there are a number of really good reasons for having an LPA. Firstly, you get to choose who to appoint as your attorneys, and I'll talk a little bit later about the choice of attorneys. Secondly, you can give them, you can impose restrictions and guidance on what your attorneys do, when they act, and in what circumstances. And you can give them detailed guidance about the sorts of things that you would want them to take into account when making decisions on your behalf. Thirdly, it's more cost effective to have a lasting power of attorney in place. If somebody were to lose mental capacity without having a valid lasting power of attorney, then the next of kin would have to apply to the Court of Protection for a deputyship order, and that's much more expensive, much more time consuming.
What is a deputyship order?
A deputyship order is an order made by the Court of Protection appointing one or more persons to represent P. The Court of Protection rules refer to P being the protected person in this instance. And when someone loses mental capacity, the legal authority to deal with their affairs vests in the court. The court then deputizes one or more persons to deal with their affairs. So in effect, the deputy is a representative of the court. And the application is quite long and laborious and very expensive, as I've said. And so another reason for having lasting powers of attorney is that it keeps the state in the form of the Court of Protection out of your affairs.
That makes sense.
Yeah. I should add that the Court of Protection order is not unlimited. It's they call it a general order, but it doesn't enable the deputy to do absolutely everything that they would want. And so sometimes you find that the deputy has to make a further application to the court to extend his powers. And of course, that adds to the cost and the delay in dealing with the affairs of the protected person.
It definitely sounds beneficial to have an LPA in place. Have you had any instances where that's been quite difficult for you to actually put in place?
Yes, I've had a number of occasions where I've gone to see a client at the instance of the family who wanted to get an LPA in place for their loved one. Excuse me, having met with him, assessed his mental capacity, I've discovered that unfortunately he's gone beyond the threshold where he had sufficient understanding to sign the deed. And as a result, the family have had to make this application for the deputyship order, causing extensive delay, additional cost, and stress to the family at a time when they're already struggling to deal with the, their relatives' illness and so on, and the fact that his affairs are frozen and no one can deal with them.
Yeah. We've talked about LPAs. I'm aware of that there are two different types, mental and physical LPAs. Are there any other types of powers of attorney?
Yes, we still have enduring powers of attorney, EPAs, and they are still valid, provided they were signed correctly prior to the 1st of October 2007, which is the date when the Mental Capacity Act 2005 came into force. And so EPAs, enduring powers of attorney, they are a precursor to LPAs, and they're not quite as wide in scope. So then, in addition, of course, we have LPAs for financial affairs, LPAs for health and care decisions. You also have a general or ordinary power of attorney under Section 10 of the Powers of Attorney Act 1971. And then finally, of course, you have a deputyship.
What types of LPA appointments are there?
Okay, what we're talking about here is the manner in which your attorneys will act. And there are 4 options. Firstly, you can have a sole appointed attorney. I guess that's the simplest. Then you have jointly appointed attorneys, where the attorneys must act together as one. Third option is a joint and several appointment, and that's where the attorneys can act jointly, but they can also act independently of each other, which is a more flexible option. And then finally, you can have a joint appointment for some decisions, joint and several for other decisions. That's more complex and requires careful consideration and drafting.
There seems to be quite a few options with appointments. Who would you actually appoint as a power of attorney? Because there's the word attorney. Does that mean it has to be a solicitor?
No, not at all. So I know in America, they refer to their lawyers as attorneys, but in English law, an attorney is just your agent, so it can be anyone. You can appoint up to 4 attorneys in the deed, and you can also appoint replacement attorneys. You can choose from your spouse, partner, siblings, children over 18, wider family members, or you can have a professional appointment. I have been asked to act for some of my clients as their attorney under a financial power, where they just didn't have anyone suitable available to represent them.
What is a replacement attorney? Is that when someone themselves dies or loses mental capacity and you need to have someone else?
Indeed. So the replacement attorney is your backup option. So if your first choice attorneys aren't available when the time comes, if you lose capacity and you've got replacement attorneys in the deed, then they would step forward and they would act in their place.
That makes sense. Now, if we're thinking about putting an LPA into place, what do you have to do for it to become valid? Is it a written document? Is it an oral agreement? Do you have to register it somewhere?
An LPA is it's a pro forma deed, so it's a document that your lawyer will complete for you, and everybody has to sign the deed. So the donor, the person giving the power, has to sign. All the attorneys have to sign, and there's a certificate provider, which is usually your solicitor. I would usually sign that for my clients, certifying that they understand the deed, what they're signing, and the implications. And once that's all done and correctly witnessed and dated, that goes off to the Office of the Public Guardian, the OPG, for registration. And the deed is only valid once it's been registered. So at the present time, there is a 5-month delay in the registration process. So it's, and I think I should add, you do need to be careful in the signing process, because if anything is out of place, the deed will be rejected by the OPG and you have to go back and start again.
Go back to the back of the queue.
Yeah.
Okay. Once your LPA is in place and your attorneys have been appointed, at what point do they step in? Who decides that?
So There is a choice in the deed. So first of all, I should say there are differences between a financial LPA and a health and care decisions. With the health and care decisions power, the attorneys can only act in the event that the donor has lost capacity. Whereas with the financial power, there are two choices in the deed. Firstly, you can tick the box indicating that the attorneys can act once the power has been registered and also when the donor has lost capacity. And secondly, the second box, the attorneys will only act in the event that the donor has lost capacity. Now that box contains a warning notice beneath it. It can make the deed less effective because financial institutions, whoever the attorneys might be dealing with, they might insist on a doctor's certificate certifying that the donor has lost capacity each time they wish to use the deed. So yeah, that can cause more delay and cost.
That's our next question: is who decides when someone has lost capacity? Is it purely doctors?
So if I'm starting the process, I would generally meet with my clients, and usually I can gauge whether they have sufficient understanding to meet the legal test to make it an LPA. But if I'm in considerable doubt, then I might bring in a suitably qualified medical practitioner to advise and issue a certificate to that effect. Once the deed has been registered and where the attorneys are acting, and if that option is chosen where the donor has ticked the second box saying that the attorneys can only act if I've lost capacity, then yes, you might need a doctor's certificate each time. Yeah.
So most people might be thinking, I'm starting to put this in place for my family members for personal affairs, but as a lot of our clients joining us today are business owners and founders, is putting an LPA in place beneficial for a business owner or an individual who's got significant shareholding in a company?
Well, what I would say firstly is that an LPA covering a person's personal finance and affairs would not necessarily extend to their business interests. And so if you are a person with business interests, it would be important to have a separate business LPA. And that can be really useful and practical from the point of view of the skill set of your attorneys. You know, do your attorneys have sufficient competence to run your business? And, you know, there's a number of issues that you need to think through there. You need to bear in mind that if a business owner loses mental capacity, once the bank get notified of that fact, the business bank account could become frozen, which would cause all sorts of difficulties. You know, suppliers, creditors, and employees can't be paid, and it could cause real problems. So, you know, without an LPA being in place, having to go to the Court of Protection to get a deputyship order, that's going to cause a lot of delay again and cost.
Yeah. If I were to give you an example where John Smith, the business owner, loses capacity, having an LPA in place, what would the next steps be? What would happen?
Okay, so if he loses capacity and the bank accounts are frozen, then the next of kin would have to apply to the Court of Protection for the deputyship order. The business may not be able to run effectively during that period of time. And if we're talking like 12-month delay, that could cause irreparable damage to that business. So yeah, it's a really good idea to have LPAs to avoid that scenario. You know, the reverse scenario where John Smith has signed his LPA, it's all registered and in place, then the attorneys can step in immediately, manage the position and protect the business going forward in a timely and tranquil manner without panic.
Yes, the business can go on as usual without panicked employees not being paid or suppliers not being paid. So having an LPA in place seems quite significant, quite a step to do. So when someone is appointed as an attorney under an LPA, are there specific obligations or requirements that they need to meet?
Yeah, so the attorneys must act under must comply with the 5 statutory principles laid down in the Mental Capacity Act 2005, which should be explained to them at the outset when they take on that responsibility. But the key ones are, I suppose, firstly, checking the deed, making sure that they comply with the instructions and guidance in the LPA document. They must comply with the terms of their appointment as laid down in the deed itself, and the statutory principles and the code of practice annexed to the back of the Act. They must act in the best interests of the donor at all times. Other duties, they'll have a fiduciary duty towards the donor, a duty to act in good faith, duty of confidentiality, and a duty not to put themselves in a position of conflict between their interests and the interests of the donor.
It seems quite onerous. What should someone who's thinking of putting an LPA in place before appointing those people, should they consider who is the most appropriate, and how do you go about deciding that?
Yes, that's a tricky one, because of course you need to bear in mind that if you're unfortunate enough to be in a position where your attorneys have to act for you, it's likely to be at a time of your life when you're elderly, frail, or ill and vulnerable. And bear in mind that LPA documents are quite powerful. Your attorneys will be able to have full control of your financial affairs. And so our advice is not to put temptation in the path of your attorneys. So we usually recommend various strategies to mitigate against that risk. Unfortunately, the Court of Protection case law does suggest that it is next of kin who succumb to that temptation and help themselves to the donor's funds. So we talked a little bit earlier about the nature and type of appointment, sole appointment, joint and several, etc. We would also spend a good deal of time talking through with our clients about safeguarding clauses that can be incorporated into the deed, and it just adds an extra layer of protection for the donor, and very important. Yeah,
I can imagine that one. Are LPAs in place in the UK enforceable globally?
In short, I suspect the answer to that is no for most jurisdictions. So if you do have assets abroad, best advice is that you should go and speak to a lawyer in that jurisdiction and find out what steps you need to take to protect your interests, your assets, should you lose capacity whilst you still retain those assets abroad.
That makes sense. Is there anything that you suggest is important for our listeners to consider? Anything else that you think that would be good for them to know?
Yes, so in terms of I mentioned earlier that the cost the registration period for LPAs, that there's a 5-month delay. And it's possible that you might have a crisis in between then when things need to get done. So there's a few interim steps that you could carry out. I'm thinking of a third-party mandate on a bank account. Now that would be automatically revoked by the lack of capacity of the donor. Similarly, an ordinary or general power of attorney could be executed. There's no registration process for an ordinary power of attorney. So once it's signed and dated, the attorney could step in and act immediately. But again, that is automatically revoked by the lack of capacity of the donor. Thirdly, the donor could sign an advanced medical directive, also known as a living will. There's an overlap there between the health and care decisions power and the living will. And then finally, we would always also recommend the donor signing and completing a detailed statement of wishes, feelings, values, and beliefs. to give, put a bit of flesh on the bone and help the attorneys understand what are their priorities, what are the things that they should take into account when making decisions for the donor.
Yeah. You mentioned health and care decisions there. What's the difference between that and a financial LPA?
Yeah, so we've probably focused mostly on the financial power, but it's worth highlighting the benefits of a health and care decisions power. This is where you would get the opportunity to document and record what you would want to happen, how you would want your attorneys to act in a certain situation. With a health and welfare power, it gives your attorneys the legal standing to have a discussion with any healthcare professional that's dealing with the donor about any treatment, medical treatment they should have or refuse to have. And of course, if the donor has signed a detailed statement of wishes, feelings, values, and beliefs, including religious beliefs, that may impact on that decision-making process about any particular medical treatment.
I think that's pretty much all the questions I've got planned for you. We've got some questions from the audience. So let's just take a quick look at those and then we can start answering them. So we've got, what is the average age someone in your experience who puts an LPA in place? Because I think a lot of our clients are between mid ages. So is it something that you leave to the last minute, or is it something someone who is young should be putting in place? So what
I would strongly encourage you not to leave it till the last minute, because that can be disastrous. Because if somebody is ill and they go over the threshold, then you're looking at the deputyship scenario. Anybody over the age of 18 can sign a lasting power of attorney. So really, it just depends on your circumstances. I would say the average client of ours would be in their 40s or 50s, but it really depends on your circumstances, what your needs are. We would always encourage our clients to sign lasting powers of attorney when they're making wills. It's an obvious time to do it. And another reason I've just thought of for having an LPA, I think I should mention, is that we're all living that much longer nowadays. And so the chance of an early death is quite slim. You're much more likely to live to a ripe old age and possibly be struck down by a mental capacity issue. So that's when LPAs can really come into their own.
That actually leads nicely into our second question, which is, do you have to have an LPA in place with a will, or can they be separate documents? Do they have to go hand in hand?
No, they're completely freestanding separate documents. So there's no overlap between the two. An LPA will remain valid up until the death of the donor. On death of the donor, the LPA is automatically terminated, and then of course the will is then enforceable as of death. Yeah.
Thanks. Let's see if we've got any more. Okay, then I've got a final question for you. Is it common where an attorney is appointed incorrectly and they use their power incorrectly under an LPA? Does that happen a lot? I know you've mentioned before there's a lot of case law out there, but in your experience of clients, does it happen?
I mean, fortunately, I don't think it happens that often. Yes, you obviously, the case law does indicate that it tends to be next of kin who abuse their power, mainly because they're the ones who are appointed. But as I said, you can mitigate against that risk by putting various safeguarding provisions in place, having more than one attorney so that one attorney is looking over the shoulder of the other, making sure they're doing the right thing, documenting their decisions, and the recording finances and when money is spent for what reason, keeping receipts, simple stuff like that.
I've just thought of one more question, actually, if we've got time for it. When an LPA is registered, how does a family member know that you've put that in place? For example, if you're not talking to the rest of your family, but you've put one in place and you lose mental capacity, how are they supposed to know that they're meant to follow if they're the ones who are mentioned in it? How do they get in touch?
Good question. So firstly, there is provision in the deed to serve notice on other members of the family that you're signing a power of attorney and you're appointing a certain person. So that's again, that's an additional, I would say, an additional safeguarding provision where you're flagging up for wider members of the family that you're appointing these people as your attorneys. That would give them the opportunity to raise objections. So when the application goes in for registration, there's a 5-week waiting period where the OPG will put it on hold and wait to see if any objections come in against the appointment, whether it's because, for example, they believe the donor has lost capacity at the time they signed the deed, or the attorney or attorneys appointed are unsuitable for various reasons. You know, they're an undischarged bankrupt, for example, something like that. So yeah, it's not a bad idea to serve notice on wider members of the family in that situation, just to flag that up.
Thank you very much. I think that was all of our questions. Yes. How can our clients, your clients, contact you to ask you more questions on powers of attorney, wills, and inheritance tax, which was the topic of our last webinar?
Yeah, have a look on our website, RIAA Barker Gillette. Sorry, it's that side. This side. Yeah, you can give us a call. I'm always happy to have a no obligation chat with clients to find out how we can help them. And if we are instructed, we will provide feedback, etc.
Just to reiterate, that links will be provided below if you're listening to a recording of this webinar today, which can take you to both of our websites. If you book a call, our contact details are on there, or feel free to email if you want a more longer question. But thank you very much for joining us today, James. It's been an absolute pleasure. I've definitely learned some more things. I need to go and have a chat with my family and my parents to put things in place. But yeah, thank you everyone for joining, and have a wonderful Friday.
Thank you, Cacy. Thank you.